And Jason is here. Okay, I'll record right now. And so I am going to introduce Jason. And so I'm going to take this straight from your bio, Jason.
Okay.
So Jason is the founder of Harper Conflict Resolution, LLC. He specializes in education and employment mediation. And he utilizes a collaborative approach, which, we all know that's the best way to go. In addition, Jason is nationally recognized for his ADR, his consultation, his conflict management. He does coaching. He's an adjunct professor, a trainer. Jason has this wonderful connection with about 100 school districts and charter schools, including LA County Office of Education. He's a lecturer of law at the University of Southern California, Gould School of Law. He teaches also cross-cultural dispute resolution. He's also an adjunct professor in mediation at Pacific Coast University. In their School of Law and the Lipscomb University, Jason has this just wealth of mediation and conflict resolution experience. He's been training adults from across the world. I mean, just 20 different countries. And he's been recognized for his work by the California State Senate and the United States Congress for his outstanding work in mediation and mediation training. Jason is the past president of the Southern California Mediators Association. We talked about that in class schema. He's also currently serves as the vice president for MC3, which is why you're all here and excited for him to be here. And he is a former graduate of NCRP. So with that, I'm going to hand this over to Mr. Jason Harper. Jason?
Hello. Thank you so much, Professor Valerie. I appreciate it. And just so y'all know, she was my mediation professor in the NCRP program. So you are in good hands. I had a fantastic time taking the course, and it made me better. So thank you to Ms. Valerie, not just for the space tonight, but for helping me get to where I am. I go back and forth on whether I consider myself a success, but as far as I've gotten, I do credit Ms. Valerie for helping me get there. So with that in mind, I want to thank all of you for being here this evening. And I don't want to take up too much time. I just want to come in here and talk about an organization and an effort to professionalize the field of mediation. That's my mission tonight. And so I will be doing so. I wear many hats, like Professor Valerie had stated, but I've worn the SCMA hat for a number of years as president of that association. But tonight I'm wearing my MC3 hat, and that is an organization that is trying to professionalize the field of mediation. So if I did bring a PowerPoint slide with me, so I can share with y'all. If you'll grant me the permission to share my screen, that would be fantastic. Fantastic. Thank you so much. So tonight I'll be talking a little bit about the background, the context of why MC3 is a thing, and what certification or MC3 certification looks like, and then I'd like to, if there's time remaining, I'd like to open the floor for any questions, as it were. So, with that in mind, I'm going to share my screen here, and the title is called "Becoming an MC3 Certified Mediator," and again, this is our attempt to professionalize the field. MC3 was born out of a SCMA task force that looked into what certification would look like or what it could look like. And so I helped commission that that task force actually, and this was in 2015 is when it really kicked off, and it's been an ever growing project over the years, and now happy to say that and proud to say that MC3 is thriving. It is a national MC3. It's a national mediator certification effort that covers multiple states, including Texas and Virginia and Utah and Oregon, just to name a few. We have some in New York as well. So that all came from SCMA, and that all came from here. So with that in mind, I'm going to go right into it. So expanding the use of mediation, one of the things that we found, particularly over the last couple of years with the growing and still present pandemic, the COVID-19 pandemic and what that brought and wrought, to our society, it forced everyone in. It basically restricted travel, and we couldn't get around and get to each other and be face to face with each other like we used to, as in what I call the before times. So what happened? We started meeting via video teleconference, and the courts, another consequence of the pandemic, the courts were closed down, and so that led to the greater awareness and use of mediation. And so with that greater use meant a few more pitfalls, and basically it led to an issue of public trust in who is a good mediator and who isn't, and who is who's reputable, and who is not. And so that in and of itself is a reason for people to really be encouraged and really curious about professionalizing the field of mediation. So the first thing that you need to understand about mediation is that it is, I've said it a couple of times, so if you caught it, kudos to you, but mediation is a field. It does not count as a profession. If you go in the business and ethics code, or if you go into just any kind of business listing, you won't find mediation as a profession. And so what does that mean? That means that we're in the other 60%, right? So 40% of the United States workforce is subjected to some sort of occupational regulation. Okay, so you could go to any person off the street and say, do you know what a doctor does? Do you know what a teacher does? Do you know what a CPA does? And they can give you, certain, there might be some variance in some of the descriptions, but overall, they can give you a good gist of what that profession looks like, what that particular person does who engages in that profession. But if you ask people what a mediator does, you will get, if you ask 10 people, you might get a smooth 8.5 different answers. So, some will say, oh, well, they're a neutral party that comes in and helps resolve issues. Some would say they help you, really relax your mind and focus on certain things, like meditation. So, with that in mind, it makes things a little difficult, right? So when we think about becoming a profession, we have to think about what makes a profession according to the Business and Ethics Code. And that has some occupational regulation, which includes, one, registering with the government. It could include registering with the government, completing a certain amount of education, passing an examination, and or demonstrating a minimal degree of competency in an objective way. All right, so those are the things that can be included in occupational regulation, right? The things that prove that you are skilled and adept at what you do and qualified, right? Qualified, and showing that there is a standard, an objective standard of sorts to meet in order to practice that particular profession. So in my time as the SCMA president, and that was a few years ago now, geez Louise, during my time as SCMA president, I heard a lot of different discussions about some of the challenges in making in achieving success. And people have different definitions of success, but in this particular definition I define success as being able to make a living off of being a mediator and using your mediation skills to sustain yourself and a family. And so the common comments I heard as a CMED president were the following. One, we don't get the respect we deserve as mediators. I deserve as much respect for my work as counsel as I am just as a professional, right? So, one of the things that was noticed over the years is that attorneys were being respected and being considered in a way that was higher, given higher status than as a mediator. Whereas as a mediator, there's years of training, right? For those of you in this master's program, in the NCRP program, that's years of training right then and there. That's not including anytime you would be working with the community mediation center and the like. So another statement is, I'm tired of everyone expecting us to give our services away for free. Now that's something that is can be a sensitive topic, for a lot of folks in the community mediation sector. That's what leads to a lot of burnout for a lot of volunteer mediators. When they're trying to pivot into a paid experience or a paid profession, people not viewing them as credible or worthy of being paid for providing a service because of the community mediation centers and the like, who are providing that service. And this is very valuable and it's great for the community, but providing that service free of charge to the general public. So it makes things very difficult, right? So are these two things connected? Right? That's a question that we need to ask ourselves. And so the common experience in small claims courts and elsewhere is disputants can't generally describe what a mediator does without being supplied an explanation. However, like I mentioned, they can often describe what an accountant does, an attorney, a nurse, or a teacher, right? Is that connected? Is there some connection between people not respecting mediators and a gap, a knowledge gap as to what a mediator does, and having some type of objective knowledge about the mediation profession? That's a question that you want to ask yourself. So when we think about the hallmarks of a formalized profession, there are a few things here, but let's go through them. The first is education, right? Often linked to a degree. If you want to become a teacher, there are specific courses that you can take for that. If you want to become an attorney, there are specific courses and a degree for that. If you want to be a CPA, there are specific courses for that. So that's education. Another is a binding ethics code, right? There are certain things or tenets to a profession that all must follow. All who choose to, embark in this profession must follow. So that's something else. It's also self-governing, a way of weeding out the non-quality practitioners. There's a mandate to keep current in the field, right? Continuing education. And if there is a licensure, there is often a test, right? That one has to complete at a certain percentage in order to continue in that profession. Currently, mediation does not require any of the above, right? What it does require is a certain amount of hours of mediation training. However, one of the things that I mention to different mediation courses is that when you might clear that hurdle of that minimum hours of mediation, but if you just stay there, you'll know just enough to be terrible as a mediator. So because of that, you're encouraged. I encourage you, just informally, just as Jason Harper, I encourage you to continue in your mediation training long after your very first one. So other professions have and provide quality assurance to the public, and that's the key here. The key phrase, quality assurance, right? Assurance of quality, letting the general public know that when you search for a mediator, when you try to get a mediator, that mediator is they're educated in the profession. They are bound to an ethics code. They have been successfully retained, and so the non-quality practitioners have been weeded out, and this person remains, and they're keeping current in the field, right? They're continually honing their craft and sharpening their skills. So those are all hallmarks of a formalized profession. And so when we look at mediator practice standards, there's a person by the name of Steve Dinkin out of San Diego in 2006 who said that if we don't decide the practice standards for ourselves, for mediators. Someone else will do it for us. And he said that in 2006. About a decade later, there was an attempt to define what a mediator was, and it wasn't mediators that was doing it. And so I'll share that as we move forward. But mediation as a profession or as a field is growing up, and it needs to accept responsibilities of adulthood, right? It's it's a little facetious to say, but mediation, as it's known now, has been around since at least the 1970s. And so, if we're looking in the 2020s, that's 50 years, right? And so, mediation, I would say mediation has absolutely grown up in that regard. And so, consumers of mediation, people that are depending on mediators to help resolve their disputes, need protection. They need a right to know how to find a quality mediator. And so there's this other aspect of the mediation field about mediator confidentiality. Now, there are codes that protect mediator confidentiality. However, those codes have been brought up to question, and they remain at risk, right? And they will remain even further at risk if we don't develop a methodology for that quality assurance. So in 2012, the American Bar Association created a task force, and ultimately what they said was, hey, we're not going to provide a credentialing program for mediators. That's not our jam. However, if somebody was going to create a credentialing program, this is what they should do. And so, based on this ABA task force report, MC3 kicked into action, and they wanted to align it with the findings of that report. And so we look into what the American Bar Association said, and they said that one, the credentialing program should clearly define the skills, knowledge, and values which persons at credentials must possess, right? So we need to have clear definitions of the skills, the knowledge, and the values. That goes to ethics. Another thing is to ensure that candidates have training that's adequate to instill said skills, knowledge, and values. Okay? And then third, be administered by an organization distinct from the organization which trains the candidate. Now, an important understanding about MC3 is MC3 in and of itself as a credentialing body does not provide training. Okay? That would basically disqualify it from being a quality credentialing program. So there are a number of training organizations, obviously Cal State Dominguez Hills included, that provide training in the skills, knowledge, and values necessary or required for MC3 certification. We move forward. Some other things that the ABA task force included was having an assessment process that's capable of determining with consistency whether candidates possess the defined skills, knowledge, and values, explaining clearly to persons likely to rely on its credential what is being certified. So for the general public, when they go and they're asking for a mediator, they know exactly what it is that they're being certified to do. And then also providing an accessible, transparent system to register complaints against credentialed mediators. That's that quality assurance mechanism. All right. So, and with that, promptly and fairly investigating complaints, and if appropriate, decredential a mediator who fails to comply with the standards. Now that speaks to that weeding out non-quality practitioners out. Okay. So that's very, very important. So finally, what should it not do, right? What should an effective credentialing program not do? The ABA says that it should not operate as a mandatory licensing. It says it should not bar non-lawyers from becoming credentialed. And 3, it should not bar disputants from selecting a non-credentialed mediator. All right, and so with that, MC3 followed this to the letter. And because of that, it's not a mandated licensure. All right. It does not bar disputants from selecting non-credentialed mediators. There's plenty of places to go and find those, and people are more than able to and capable to do so. And MC3 does definitely not bar non-lawyers from becoming MC3 certified mediators. One of the things that I think is very important is that we make a distinction between the practice of law, from lawyers and mediators. They're exercising completely different muscles. They have completely different processes. And while one might be related to the other, they are not the same. And so, because of that, an effective credentialing program should not bar non-lawyers from becoming credentialed. So one of the things that I mentioned a second ago about mediation as a field needing to grow up and accept responsibility. One of the things that happened is, if we don't define, in 2006, Steve Dinkin said that if we don't define what a mediator is, it will be defined for us. And so, what I was alluding to at that particular moment was what happened in 2018. About 4 years ago, the LA Superior Court, the largest court in all of the land, came out with an RFP to revive their dispute resolution program. They had had one for years up until about 2013 when they did away with it. Now, in 2018, they provided an RFP asking for, mediators or some type of body to provide mediators for the LA Superior Court to handle cases. Here is what the LASC RFP asked for. That for the mediators, they asked for 10 years of active California bar membership only. What does that tell you? That tells you not only do you need to be an attorney, but you need to be an attorney of 10 years. Okay? And that's a de facto rejection of the ABA task force report that studied mediator credentialing and recommended having diverse pools. Okay? So, with the LA Superior Court RFP, what ended up happening was they're asking for 10 years of active law practice, but the minimum required hours of mediation training, right? Now, does that make a quality mediator? No, it does not. And thank you, Melissa, very much. An RFP is a request for proposal. So for anyone that is interested in being a part of a particular effort that's going on, an organization will list an RFP, a request for proposals, where applicants would present a proposal of how they could serve that particular organization with what it is that they're asking for. All right. So, but in that RFP for the LA Superior Court, the LA Superior Court required 10 years of active bar membership and the California bar only. MC3 certification is a little bit different. It accepts a diverse pool as there is no demonstrated correlation between a JD degree and mediator skill. Right? Mediators without law degrees will be required to complete a 3-hour litigation nuts and bolts program, and that is only so that you understand and make sure you understand the terminology that is said in court. Okay? So, moving on. Thank you very much for that, Melissa, by the way. Another thing, the LA Superior Court RFP also stated 40 hours of mediation training. They required that. Now, the requirement of 32 hours in a comprehensive program would exclude a lot of DERPA organizations, and by DERPA, I'm referring to Dispute Resolution Programs Act. And those are the community mediation centers that provide a lot of mediation training. And so some of those mediation training programs are 32 hours in length. And so with a 40-hour mediation training, that would completely take out a lot of those very high quality DERPA trained organizations or DERPA trained mediators. So what does MC3 certification provide, or what are they requiring? Well, MC3 likes to set itself aside as the gold standard for mediators. And so, with that in mind, they're requiring 80 hours of mediation training. Now, some of which can be offset by completing degree programs. Okay? So, with that in mind, from an education standpoint, MC3 is definitely wanting to ensure quality mediators from an education standpoint, not JDs who happen to take a mediation training. All right. So, other LA Superior Court RFP request for proposals requirements were 12 hours of mediation experience, 7 hours of continuing education every 2 years, and with no quality assurance program. MC3 is a little bit different. For mediation practice, you need to demonstrate 50 hours of mediation experience, and as well as 20 hours of continuing education or continuing training every 3 years, and an hour and a half of those hours must be in mediator ethics, right? It's very important that we continue to, one, remain sharp, but two, rededicate ourselves to the ethics of mediation. All right. Now, for quality assurance, the system for MC3 certified mediators is modeled after the California Rules of Court in court connected cases. More on that in a little bit. And so, when it comes to ethical requirements, the LA Superior Court looks to the California Rules of Court, right? But MC3 does the exact same thing. So there are similar ethical requirements, but this is all an exercise to show you that when left to their own devices, people will try to define what a mediator is. And more often than not, that definition of a mediator is not what we would define ourselves as mediators. And so that's why MC3 wanted to kick in gear and really provide that definition by us for us. All right. And by us, I'm referring to mediators, and that's extremely important. So, by raising the bar, I talked about what makes a formalized profession and how, and I want to talk about how MC3 satisfies that. This is kind of a summation of the tables that you saw a second ago. But a formalized profession, education often linked to a degree. MC3 certification definitely has that. They're requiring 80 hours of training as well as education, and the degrees can offset some of those hours that are required. There's a binding ethics code, and MC3 certification binds our MC3 certified mediators to the American Arbitration Association, the American Bar Association, the Association for Conflict Resolution, as well as all of their ethics codes would be bound to for our MC3 certified mediators. It is self-governing. MC3 has an ethics complaint process. That's the quality assurance process that I talked about a second ago. Continuing education, keeping current in the field, that's a hallmark of a formalized profession. MC3 absolutely provides that, and they require continuing professional education and activity. And then, often a test for a formalized profession, and MC3 certified mediators have to pass a judicial council ethics program test that is connected to the LA Superior Court, but it tests on mediator ethics, which is, I can't stress enough, extremely important. So, with that, what does the MC3 application process look like? Well, I'm glad you asked. So, the qualification process requires a total of 200 points, and that's required for initial certification by meeting 3 components specifically: the education component, the mediation experience component, and the professional activity and continuing professional development component. All right. Now, 40 total points are required to remain, in the continuing professional activity. That's going to be required to maintain your MC3 certification every 3 years. All right. We'll talk a little more about that in a second. So let's start with the education component. You need 80 hours of mediation-specific trainings from organizations that are acceptable to MC3, right? And you get a point for each hour of training, and that includes these specific organizations and universities. And if you notice, it comes up number 3 in this list, but number 1 in our hearts is the California State University at Dominguez Hills. That is an organization and a university that provides excellent mediation training. Shout out to Professor Valerie. Now, with that in mind, there's 80 hours of mediation specific training. However, a minimum of 25 hours must be completed from one discrete program. Okay, so you have to get 80 hours of mediation specific training, but at least 25 of those hours has to be from one whole program. Okay. You can't do a 10-hour training 8 times. You have to, at least one of those training organizations or one of those training programs has to be at least 25 hours in length. Okay. Now, that shouldn't be too hard because a lot of the organizations that I listed in the previous slide provide 40-hour trainings, if not whole courses in and of itself. Okay. So the other credentials that could add to your point total is a postgraduate degree in conflict resolution from a nationally or regionally accredited institution. Now, here's where it gets interesting for the fine folks at Cal State Dominguez Hills. You can get 40 points docked off for having a degree in negotiation, conflict resolution, and peace building. Okay? Now, that's if you just got that, Obviously, you'd have to show your transcripts in order to, fully qualify. However, if you can show that you have completed a master's course in dispute resolution, that could be 40 points deducted from your 80-hour requirement. Okay. However, if you can present that degree and also show that you took a mediation course within that master's program, that would satisfy all 80 points for the education component. So if you are taking the NCRP master's program and are taking the mediation course, you have completed the education component for MC3 certification straight away. You don't need to go to another. Mediation training program. You have done it right then and there. All right. And the reason being is that you have absolutely studied mediation. You have studied the ethics and all the courses that come along with that NCRP master's program, and it's fantastic. So another way to offset is a professional degree in law, whether it's a JD or an LLM, or a PhD in any discipline that is from a national or regionally accredited institution. And that would dock off 30 points out of the 80. So with a JD or a PhD, you would only need 50 hours of training, of mediation training. Then a master's degree from a nationally or regionally accredited institution, that takes off 25. So you can do the math, how many points or how many hours of training you would need from there. For a bachelor's degree, it would take off 20 points. For an associate's, it would take off 10. All right, so 80 hours total required, but it's offset by what kind of degree that you have. Now, you can't come in and say, well, I have an associate's and a bachelor's, so I can get 30 points off. Doesn't quite work that way. Very clever, but it doesn't quite work that way. So that would only dock off. You would only get the total, the points docked off from your highest level of education completed. Okay, so if you have an associate's and a bachelor's, then it would be 20 points off because you have a bachelor's, right? So that's how it goes. Another part of the education component is the distance learning. The distance learning of the administrative office of the court would fulfill this requirement for all the way up to 2022, and we have gotten that extended. That's another 30 points that would be necessary. So a distance learning course on mediation ethics that is offered by the administrative office of the court. And if you go on the MC3 website, it can forward you to that particular program. In the chat, I saw a fantastic question. The field experience is waived with an MA and mediation class? No, not the field experience, the education experience, to be clear. So it does not waive you from proving that you've provided mediation training, or not provided mediation training, but provided mediations, that you've handled mediations. That's a whole different category. We're still in the education component, and if you have a master's with a mediation course, that would satisfy the education component, not the mediation performance component, and I'll get to that in a second. All right, it's an important distinction, and I'm glad that we can make that here. Moving on, there's also a minimum 3 hours litigation nuts and bolts training from a single training provider. Okay, now the provider could be the same one used to complete the 25-hour requirement, but the curriculum for that litigation nuts and bolts, one is for legal terminology, two is litigation processes, and the rules and procedures. Okay, now what is the purpose of this? The purpose of this is to make sure that if you're going to do court mediations, you understand what the terminology is and what the processes are, so that you can bring your best self to that particular environment. Now, if you have a JD or if you have a LLM, you'd be deemed to have met this requirement. So you would be exempt from taking the litigation nuts and bolts. Another way to be exempt from that litigation nuts and bolts class is you have to show proof of performing at least 10 litigated case mediations at the limited and or unlimited jurisdiction level, not including civil harassment. Okay? So if you can show proof that you've done at least 10 of those litigated case mediations, then you would also be exempt from this litigation nuts and bolts course. There's another question that says, will the conflict resolution course count as a mediation course? Well, if the conflict resolution course covers what a mediation is and the processes of a mediation potentially. One of the things that you would have to show is the syllabus for that particular conflict resolution course, and if it covers the required knowledge to that would demonstrate mediation knowledge, or the knowledge of the process of mediation, then it would count. All right. So with that in mind, let's move forward. All right. So, well, before we get to the mediation experience component, let me just say this one thing. For those that in this education component, if you took an ethics course, if you took, if you got your master's degree, if you got your bachelor's, if you got your mediation training, it doesn't matter. If you're an initial applicant for MC3 certified or MC3 certification, your initial education could be there's no limit as to when you had to do it. So if you did it, you don't have to do it again. Just show that you did it, and you're all good. Okay. Now, when you want to recertify yourself, if you want to recertify yourself, then you will have to show that you are continuing in your education. However, for your very first, from the education component, for your very first initial certification, you can bring in any education that you've had. If it's a mediation ethics course from 1998, bring it. It will count. If it's from 2008, bring it. It will count. Let alone 2018. All right. So I want you to understand that as we move into the mediation experience component. So the mediation experience component needs to show proof of mediations, right? So a minimum of 10 cases mediated or co-mediated, and that's 1 point per hour that you mediated, or a half a point per hour in the event that it was a co-mediation. All right. So you have to show a minimum of 10 cases, and you have to get a minimum of 30 points for those proof of mediations. All right. A minimum of 30 points, but a maximum of 50. Okay. So we'll talk about the 30 points and how you can offset that, because you need 50 points total for the mediation component, for the mediation experience component. Now, candidates must attach a list of their cases and will be asked to provide detail on their role in the mediation and the dates and length of time for those cases. Now, you would be required to affirm to the mediations under the pain and penalty of perjury, to attest and affirm that those mediations did in fact happen, as well, including the length of time for each. So, one way to offset if you don't have 50 hours of mediation experience providing mediation services, then if you can get 30, then here's how you can get the other 20. Okay, so you need to provide mediation support and or ancillary activities that are acceptable to MC3 with a mediator provider organization. So if you are helping out CCR out in Reseda, the Center for Conflict Resolution, or another community dispute resolution center, that could help in your ancillary activities or mediation support experience. And so looking into the examples that are listed here, such support roles may include but are not limited to the actual mediation observation, case management, case intake or convening, facilitations, conciliations, mentoring, and my personal favorite, peer mediation. Peer mediation. So candidates intending to qualify for these points available in this category will be required to submit a letter from their supervisor that's validating each role and their experience. And again, you get a maximum of 20 points for that, and that could help you get to the 50 points that are required, the 50 total points in the mediation experience component. Okay, and to be clear, purely administrative tasks such as clerical tasks where there's no direct contact with the mediator or the parties does not qualify for points. Okay, so make sure we're clear on that. And I see there's another question that I want to make sure that we can address. Where can we go, or who do we seek out to get this field experience for court mediation and commercial mediation, not necessarily community mediation? Well, that's a great question. There are a number of dispute resolution organizations, community mediation centers that also go to court and do you know, the types of mediations that would fit into the experience component for MC3 certification. For example, OC Human Relations. They go to the Orange County Superior Court and they will do landlord-tenant disputes, day of hearing mediations, and that's a fantastic way of building your experience and getting that mediation experience fulfilled. All right, so that's just one example. There are a number of others, and you know, you're more than able to go in and take a look at those. Okay, so moving on. Then there's the professional activity component. Okay, 40 points required for all candidates, and the activities must have been completed in the 5 years immediately prior to applying for the initial certification. So let's make this distinction clear. The education component for initial applicants, you could have gotten that education at any point in time. As Vice President of MC3, I have seen applicants of where they list their master's degree from 1988. Okay, now that was a little bit of time ago, but it still counts. That was their initial certification. That's their education component. That is fulfilled. All right, so that absolutely counts. However, if you're doing the professional activity component, any activity that you've done in the last 5 years before you applied for the initial certification is all that will count. Okay, so that means if you're applying in 2022, you can't go any earlier than what year? That'd be 2017. Thank you all so much for playing. That is, you know, the math. The math is mathing, as it were. So, with that in mind, this component's requirements must then be met every 3 years for continuing certification. I know y'all were not expecting the math. I'm a recovering math teacher in a former life, and so I always like to throw that out every so often just to see the reactions, and it's always fun for me. So moving on, let's talk about this professional activity component. So training that enhances the practice of mediation from organizations acceptable to MC3, right? 1 point per hour, you get a maximum of 20 points for that, and at least 3 of those points must come from attending a mediation ethics program. Now, the candidates, you can prove your education with certified transcripts, certificates of completion for these training programs. So what does that mean? That means that when you go to a mediation training program, you need to keep that certificate, okay? Hold on to your stuff to prove that you actually have the education that is required, that is deemed as acceptable, and showing that, you know, hey, you know what you're doing here. That's very important. So initial certification candidates may use training hours from the education component to satisfy this requirement, provided that the training was in the previous 5 years. Okay, so that 1988 degree is not going to cut it, but that 2018 program that you went to, that will count. Okay, so keep in mind on that front, and we move to other professional activities. If you have membership in a professional society or organizations relevant to mediation, you know, you can get that, and there's 5 points for each membership with a maximum of 10. Oh, we got a hand up. Professor Valerie, go ahead.
Oh, sorry, Jason. I just wanted to ask you, when you talked about ancillary activities,
yes,
does that also include coaching?
Yes, it does.
Okay.
I consider coaching and mentoring, you know, one and the same.
Okay, because we've had some students do that as well. Absolutely. So, okay.
Yeah, no, that absolutely counts. That absolutely counts, 1,000%. So, you know, the category, when we talk about membership in different professionals, that professional societies rather, that includes ADR sections of various bars and associations. Obviously, SCMA, the Southern California Mediation Association. NAFCOM, the National Association for Community Mediators, ACR, CDRC, etc. And again, it's 5 points for each membership with a maximum of 10. Other professional activity components, published mediation articles, or if you presented at conferences in areas or subjects relevant to mediation. You get 5 points per presentation with a maximum of 10. Now, while not all articles or presentations would be acceptable to the standard, training that is an enhancement on the core content enumerated in the education component would presumptively qualify. I say all that to say, you know, just send it in and see if it counts. All right, just do that, and hopefully good things would happen. So that's publishing mediation articles. I highly advise you to do that. I think it's always a great thing to do. Awards for professional contributions to mediation or mediator accomplishments. Okay, so first and foremost, an award for participation in a program would not qualify. Okay, so if you are being honored for something that you have provided to the field of mediation, that would count, and it's a maximum of 10 points, and you get 5 points per award. And so I'm not going to ask how many awards that would be to meet the maximum. I'm not going to ask that. I'm not going to ask.
2.
Because that would be all right. That was a Jedi mind trick. I was hoping somebody would come up with that answer, because that is some division for the good time. All right, moving on. Okay, so another professional activity component. If you teach in a university conflict resolution program or a law school ADR course or trainings recognized by MC3, you would receive credit for that as well. All right, now that can give you a maximum of 10 points, 5 points for each training. So if you do find yourself teaching a university course or teaching or helping train people in mediation skills, that will count. All right, and we want to recognize and honor that. It's extremely important. And then, proof of mediations, right? So you can get a maximum of 20 points. You can show that you are currently mediating and have that be a part of your professional activity component, right? And obviously this is within the last 5 years. And much like in the mediation, experience component, you would get, it's a minimum of 10 cases, or 1 point per hour, maximum of 20 points, and you would attach a list of those cases, and you would be required to affirm those under the pain and penalty of perjury. All right, and then much like the mediation, the mediations itself, if you provide mediation support within that 5 years, we count that as well up to a maximum of 20 points, and that's a total of 40 points for the professional activity component. So when we look at the baseline elements for qualifications, these are the baseline qualifications, right? So if you stripped away everything that I talked about as far as, if you have this can offset this, regardless of all of that, here's what you need without any kind of caveats. You need 80 hours of mediation training, 25 of those hours from one discrete training program. You would need to mediate at least 10 cases. And then you would get 40 points total from various activities. 20 of those be 20 hours of training, including 3 hours of ethics. All right. So if you have any questions, or if you want to think about next steps, I would absolutely go forward you and encourage you to go to the website. That is mc3certified.org. That is mc3certified.org. You will get all the necessary information there, and you would get any answers that you're thinking of answered there, and also you can start the process of applying for MC3 certification. So with that in mind, I will make myself available for the next few minutes if there's any questions.
Hey, Jason. I have one, Jason.
Okay, let's hear it.
So the ethics course, I know when Julie and I met with, who did we meet with, Julie? I can't even remember his name.
It was Chris Welch, I believe.
Chris Welch. We approached him initially to meet with him to find out for the students where they could go to take the ethics course. Have they identified a place or organization that I can refer the students to?
The ethics course. Now, typically, what I will say is there a lot of training, a lot of mediation training programs have the ethics component embedded in their training program. So, that's one way of just getting that just free and clear, knocked out, right in one fell swoop. So, I would encourage folks to do that.
Okay.
Yeah. And then also, I would also, if you're looking for just a straight ethics program, I believe the American Arbitration Association, AAA, or AAAmediation.org has those courses as well, if I'm not mistaken. So definitely check them out too.
Hey, Jason, Melissa here in San Diego.
Hi, Melissa.
Thanks for a fantastic presentation and for being the architect of this certification. I really appreciate your time. I put a question to you in the chat. And I think many of my peers, what I hear a lot of chatter of in our program, and I'm in the first 6 months of the program, is that many of us are looking for a list of who to contact and where to go to for those types of mediation that Professor Valerie dropped in the comments. Yeah. Court mediation and basically non-profit. And so I think so many mediators just are like, oh, just go to Google and search for this. And what they don't realize is that we don't have that language yet to even conduct those searches. So I don't know if there's someone at your organization or if there's a list somewhere that we're not privy to, but many of us are eager to simultaneously, while we're getting our degree, already be working to complete the field components of the MC3 certification. Mm-hmm. And I just wanted to see if there was any headway we could make on that while we have you here.
What I would recommend is reaching out to organizations like the Southern California Mediation Association. SCMA is the clearinghouse. It's the hub for the mediation community. Not community mediation, but the mediation community. Slight difference there, but huge difference. So what I would recommend is go to SCMA's website, and one person that you could contact that could get you that information is their executive director. And you could contact SCMA, and they could more than likely get you a list of those places that do provide those opportunities for those mediations.
Great, thank you so much. And may we have your contact information? Is that something you're going to leave with us today?
Absolutely not. Once I leave here, I'm absolutely gone. So yeah. But I wish you all the best. No, I'm totally kidding. I'm gonna put my contact information in the chat, and if you have any questions, then please feel free to reach out. I'm gonna put it in the chat right now.
Thank you.
Jason, I have another question. For the nuts and bolts, I've been around a long time, so I took my nuts and bolts training when MLK dispute resolution program was up and running. So, that's been a minute. But for
I know that's right.
For these students, is there, or would you recommend, or should they just follow up with SCMA to identify where they would go right now when they're still in school to take the nuts and bolts?
So the nuts and bolts, I mean, those courses can be they can be slippery. However, I would refer people to SCMA. They're, again, like I said, they're the clearinghouse. If you have a question as far as where to get the nuts and bolts, as far as where to get potentially the mediation experience, then that would be the one-stop shop that I would recommend for any kind of information that you need as far as that particular endeavor. May, I see your hand up.
Hi, just a quick question. Just looking forward ahead in the future, where do you think mediation is going to be in terms of professional, not certification, but like getting it to be, I'm losing my brain. It's like, wait.
It's all good.
It's like, when we're going to get, what's that called? I guess like the bar association. I'm sorry, I'm losing my
Okay, so
triple.
when do I see mediation rising in stature to like a bar association or
Yeah, like are we ever
okay.
going to get regulated, you think?
Okay, so regulation, when you talk about the bar, so that you're referring to a state and a state regulation, basically.
Mm-hmm.
Um, and that is something that, do I see that happening? Potentially. However, what I would say is that the states typically don't know, the specifics, the ins and outs of a given profession, right? Individually, states don't know individually in a given profession what the ins and outs are. So what do? They rely on people to provide them that information, and
Mm-hmm.
that's where MC3 comes in. We've had conversations with different folks in the legislation in regards to what those qualifications might be in the event that a state would want to adopt particular qualifications. And so this is a way for mediators to help define what mediation is, as opposed to a completely separate body in a completely separate industry saying, oh, okay, well, this is what those folks over there are going to do, and this is how they're going to do it, and this is what's going to be required, whether or not it actually lines up with reality.
Thank you. I just hope one day if that does happen that we'd get grandfathered in. Hopefully.
Yeah, well, the thing about those kind of situations is grandfathering in. You don't really see that happening, particularly with state legislature or state licensure, and you don't necessarily see that with MC3 either, because what happens with grandfathering is that it reduces the credibility of the credentialing body.
Okay.
Yeah.
Thank you.
Hey, anytime. iPhone 510. What's going on?
Okay, it's Peter Fletcher.
Hi.
Hi. Thank you so much for this. This is great. So, as a real estate broker for many years, I have associations with the National Association of Realtors and the California Association of Realtors and so forth. And that is what allows me to be a realtor rather than just a licensed agent. And I think it's partly what's going on here is that we're not just capable of doing a mediation, but we are working at a level that separates us from the masses. And I like
Correct.
that. And I certainly like the code of ethics. I think that's the only way to fly. How long have you been around? How many members do you have? And how much does it look like it will cost to certify every 3 years?
Okay, so let's start from the top. So MC3 officially launched in 2019. Perfect timing, right? But in that time, like I said earlier, it has spread to a number of states within the union, namely Texas, Virginia, New York, New Jersey, Utah, and Oregon. Last I checked. So yeah, it's definitely making ground, and it's currently being used as a clearinghouse for mediation panels. The California Association of Realtors, for one, in their for their mediation panels, they only use MC3 certified mediators. So that's
Cool.
one example. And so for other panels, they're in talks with MC3 to require MC3 certification to be on their mediation panels as well. So yeah, so it's been going on since 2019, and the growth has been steady and positive. As far as the cost for recertification, that's 195, if I'm not mistaken. But again, please go to the website, and it'll have all the information there.
And one last detail on that.
Yes.
I guess I'm somewhat curious as to why there is both a continuing education component and a number of cases component. So
Oh, go ahead.
no, that's good. It's fine.
So the reason why there's a continuing education component as well as a mediation experience component is
Yeah.
because if you just sit in the classroom all day and just talk through theory, that's not practice, right?
Amen.
So you need to have both. So
Okay.
not only are you reading about it, you're doing it too, and you can't have one without the other.
Okay, thank you.
No problem. No problem. It's 5 after 7. That's my time, y'all. I appreciate being here in front of y'all. This has been fantastic. It's been really fun, and obviously, I think I left my email in the chat. So if you have any questions, feel free to ask. Shoot me an email. But also, just want to let you know, for more information, go to www.mc3certified.org. All right, that's mc3certified.org. Thank you all so much for your time this evening. Stay safe, stay healthy, and hopefully I'll see you again at some point.
Thanks, Jason. That was
one last
great.
Question: Are you going to leave this beautiful PowerPoint?
Oh, absolutely not. But I wish you all the best. I wish you all the best. This has been fantastic. That'll never happen. But if you just remember what I said, I think everybody will be just fine. I'm totally kidding, Renata. I will send it to you. I'll email it to you. Everybody can have it. Totally kidding.
Thank you.
Hey,
Thank you,
anytime.
Jason.
Thank you
All
so
right.
much.
Thanks,
Good
Jason.
night,
Take care of
everyone.
that baby and the wife.
I will. I certainly will. Y'all have a good one.
Okay. Thank you. So, just for a few minutes before everyone, logs off, there are some things that you can do while you're in school. I know people say, I don't want to volunteer, I don't have time. But in order to meet some of these requirements, because we don't have a court-connected program here, you're going to have to go out to a community mediation center to try and get those 10 cases. That's something we've been working on for the past year. Julie and I have been, we just had a meeting 2 weeks ago with Dr. Jarrett about it. If we could bring a court-connected program, that has a win-win. So you all would be able to get that, 10 cases, get the experience. The community would have the benefit of having you all serve as mediators to help them, problem solve. And it builds, I think personally, because that's the way our program was structured, it cements the university's commitment to the community, to be of service to the community. That's the one thing I told Dr. Jarrett when I first came here. I'm like, you guys don't have a service learning component?
Yeah, that's shocking. It was shocking to me when I got into this program and found out we didn't have it. I presumed that we would. It is shocking. You're right.
And it's very disturbing to me is that you have all this theory, but you have no practical experience. And whether or not you decide to get professional licensing or not, when you go out and go into the field as a practitioner, if you don't know how to manage the dynamics of a case, because you don't have that experience, it's going to be extremely hard. And that really, really upset me because I'm like, you can only get so much in terms of a simulated activity. Because, your peers, everybody wants to kind of play nice, except for Tamar and I, we don't play nice. But it's not the actual experience that you would get when you're dealing with high emotions, when you're dealing with crisis, when you're dealing with positions and people being entrenched. You need to be able to handle a real case. And so having that experience is something that I just think is needed. And like I said, Julie and I have just had a conversation about this. It's so important for you all as practitioners that you need that practical case handling experience. You can know how to assess things, you can know the order and the function of a mediation process in your head, but how does it play out when you're dealing with people? So that, again, that's just something, if we can never get this court connected program at the university, you all will have to go to community mediation centers in your community to get those 10 cases, to get that experience.
Professor Valerie, what is your biggest obstacle with making this court connection? I understand it's been difficult.
There's been concern about liability to the university. There's been expressed concern around, who would be, say, for example, on site if you were assigned to work in a specific court, who would be there to supervise. And then the other piece is, whether or not you all as students and, practitioners, whether or not, when and if you are able to, kind of fly solo. So it's, for me, I think personally, it's really the liability to the university that they're most concerned with. Because all it takes is for someone to say, one of you all to say inadvertently to someone, well, I think you should do this. And you're not thinking that someone's going to come back and say, oh, well, Melissa said I should do this.
Mm-hmm. How does
then the university becomes liable?
Forgive me, Professor Valerie. Thank you for explaining that. How does Pepperdine, they're in our hood, they're in our neighborhood, they're going after the same market. How do they circumvent that? Do they have more resources to pay for higher liability? Do they have an extra staff and training? How are they able to do that where we're hitting a wall?
Pepperdine certainly has more resources, and they are actually connected to a larger network. Julie mentioned Chris Welch. He also serves on MC3, but he's also a director of a mediation program. So they're connected to, this broader group of practitioners where they have the human capacity to have someone on site.
I see.
They also have the contracts. When I first came to the university, I went straight to Torrance Court to see if I could get you all into, mediating the small claims disputes. And I was told, no, there was a contract. At the time, I didn't know who held the contract. I just recently found out. And so you have Pepperdine, you have USC, you have UCLA. They have a lot more resources.
Well, those are long-standing relationships for sure. I hear you. My next question is, has anyone considered actually pairing with one of those universities and asking if they'll lend us can we pair one of our students with one of their more experienced students? Or have we considered developing a third party business that actually assumes that liability and merely places the students in those positions?
We have not. Without saying too much, what I can say is that the conversations just kind of, hit a wall when the reality presented itself in terms of liability and the cost. And this program is not one of the larger programs on campus. And so the resources are very, very small. And so it was just made really clear. The best way I can say is just, Renata, slow down. You're moving too fast. And so I took that, it's like,
really well, I bet.
Yeah, I'm speechless. I can't even tell you how I took it, but it was, that's what I was told, don't ask for too much.
Yeah. So this is what's happening with the dean. I understand this is happening across the university. I mean, I know you're not saying that, but I'm saying I hear that. And thank you for letting us know what some of the obstacles are. As mediators, we're really good at finding solutions when we hit walls. So I think we might have to think outside the box on this, even if that means getting our funding from a private grant and building our own third-party company that we then put a liability policy on and we place students through that company. That would be a workaround. And of course, that would take time and effort.
It is. It's something that, I've thought about.
Professor Valerie,
Yes.
I just have a suggestion maybe because of the work I was doing prior to becoming a mediator, I was able to observe mediation proceedings for
Mhm.
so many years. I think it would help even if you the students would go to the courts and ask to be observers during mediations, because up here in Alameda, we have had Berkeley students come and observe mediation proceedings, and they allowed that. So just being exposed to that real type of litigation mediation is so useful.
Well, that is certainly something we could approach Dr. Jarrett about, and it has to go through this formal process. Everybody's got to approve it, and that's, for me, that's the other thing that drives me bananas. It's just the layers of bureaucracy that
Yeah.
things have to go through, and it takes so long.
Yeah.
It's like by the time you do this, half of you all will have matriculated already.
Uh-huh.
The,
I would
the other thing
do it
that's
on
been
my
a
own,
challenge,
like go out on my own and do it, if the others want to do that. Yeah.
For those of us that have graduated, we can do that, I think.
Yes, you
Just go out
can.
on our own.
Yes.
You
and the
can,
other
but-
thing that makes it complicated a little bit too, are there's a lot of changes and growth happening in the courts too. So, some things were mediated online, and we're kind of crossing that crossroads where they're deciding whether they are going to go back in the courtroom 100%, what's going to be in the courtroom, what's not. And since some of our programs all online, we have to look at where everyone's from. And, if you're out of state, we don't have as many resources to connect you and, another state as we might hear and stuff. So we were looking at things like that too. And not everybody lives in LA County, so.
And the other thing we found out in our conversations was the courts are desperate. They're desperate for you all. They're desperate for students.
They
In
need
December,
us, and that's what's so frustrating.
the moratorium on the evictions will be lifted. And so they're expecting this onslaught of cases where, evictions, these 3-day pay or quit evictions are coming through. The other cases that they're seeing just so much of is the civil harassment claims. Either the tenants are filing civil harassment against the landlords, and the landlords are filing civil harassment complaints against the tenants. So they're looking at all of these cases coming through. And that's why they initially, when Julie and I met with them, we wanted to find out about the ethics course. We wanted to find out where you all could take the ethics course, where you all could take the nuts and bolts. We were just trying to find out the general information, the training, who, what, where, and how. But then that conversation quickly shifted and said, can you all provide us with students? We don't have the capacity. And I thought, I'm like, yeah, you got a bunch of NCRP students. Yeah, we can do that. But then when I went back and presented it, and there was a subsequent meeting, and we came back, and it was just Renee to slow down. So that's how I was left.
Did you ask them, did they say the reason they wanted you to slow down was strictly funding? Did they give you a reason? Did you say, why do I need to slow down? Did they give you a reason?
Yeah.
Funding?
Funding was one. The program, NCRP, is small, and it doesn't get a lot of resources. It also doesn't have a lot of support.
Well, we sure would have a lot more if we had a relationship with the courts. How limited can their vision be? Limited. Okay.
So it was like, no. And so when I said, well, the way I envision it, there was conversation like, oh, well, you can't change the classes that we offer. You can't change the structure. Because I said, well, why can't we do the ethics course? That way our students get credit right here, right now. That's 30, that's 30 units or 30 credits. Well, you don't want to take away from someone else who's been doing this work. So that was out. Then I said, well, what we could do with 532 is integrate an externship. And everyone who takes that class would be required to go into a court, and hopefully we'd have that connection for them and get those 10 hours. You know, Julie and I have spent a lot of time trying to figure out how we can make sure before you all matriculate out, how we can, you know, create some of these opportunities so that you can meet the licensing requirement.
We just need to form an external company, and we need to feed students through it and have that external company contract with the courts that are approaching you. This is not rocket science. This is just opening an
and it's
LLC.
not.
Buying insurance.
But the other thing, and I'm going to say this to all of you, when that was presented, and I, you know,